2017 Delaware Public Service Commission meeting. I didn't see a bus pull up outside, so I guess we're going to have we'll be able to get home before 5. I would like at this time, is Malika present?
Yeah.
If you would be kind enough to come up here, Malika. I have two recognitions today, and both of them are for service. And Malika, thank you so much. It's 15 years service. Just 15 more years to retire. Thanks, now.
Thank you.
You want to give a speech?
No.
Okay. And the other person's already coming up. Look, it's Bob Howard. 15 years with the Delaware Public Service Commission, or the state of Delaware, rather. And don't go anywhere, Malika. I forgot to give you your diamond tack. Can I have her service? No, I'm going to give you your own. And there's a 15-year recognition of 15 years of service with the state of Delaware. I thought it was 20.
Most of it's within ranks.
It seems like 20. No. But he says he's going to get his 30 years in, so I was happy to hear that. But Bob, thank you so much for all you do.
Thank you.
Much appreciated.
We'll compare later.
Oh, super. So we have no meeting minutes to go over this afternoon. We do have the consent agenda. Excuse me. With 4 items on it, any commissioner want any of those items to come off or not be on the consent agenda?
Move that we adopt the consent agenda as presented.
I seconded.
Any discussion on the motion to approve the consent agenda? Hearing none, all in favor signify by saying aye.
Aye.
Any opposed? Any abstentions? The motion carries. The regular agenda, the application of Delaware Power and Light Company for approval of the 2017 program for procurement of solar and renewable energy credits. So proposed order number 9043, which would approve
9045.
Yeah, that's what I said, 9045. Which would approve opening this docket and setting deadlines for publication of notice. This is going to be kicked off by Pam Scott unless she's not here, in which case it's not going to be kicked off by Pam Scott, but I guess Mr. Willard will take the ball and run with it.
Well, as you said, this order opens the docket and sets deadlines for intervention and for comments, public comments, etc. Application was filed on March 24th, and they did seek an expedited review of this. And it was based on the recommendations of the task force, which recommended that the auction for solar renewable energy take place no later than May 1st. So that's why we're here so quickly. Deadline for written comments was April 14th, and for interventions, Campbell Hay is going to be named as the hearing examiner, and there will be an evidentiary hearing on this on April 20th at 1 p.m. at the commission hearing. And so therefore the staff has asked you to approve order number 9045.
Thank you, Mr. Willard. Ms. Iori.
Unfortunately, I didn't review the order. Boy, that's fast. But I guess we'll comply with it.
Okay, well, thank you very much. Is there anyone else or any other party here to speak on this matter? Seeing none, any commissioner have any questions of any of the participants? A motion, please.
Motion to approve order number 9045.
Second.
Any discussion on the motion to approve proposed order 9045? Hearing none, all in favor signify by saying aye.
Aye.
Any opposed? Any abstentions? The motion carries. Thank you, Mr. Willard.
Mm-hmm.
Actually, I just thought something. The 14th is still holiday.
Oh, you're right. And I believe the order does say the deadline for, so again, under normal state rules, that would mean that it would be extended to the 15th, I think pretty much automatically.
Saturday.
That's Sunday and Monday.
So it'd be Monday, I guess,
17th.
17th,
17th?
13th, 14th, 15th, 16th, 17th.
Is there a reason why the feds decided to take taxes on the
Yes,
18th?
because something's on the 17th.
I don't
number 2 on the, I'm sorry, that's the regular agenda, the hearing schedule. Number 1 is in the matter of the adoption of rules and procedures to implement the Renewable Energy Portfolio Standards Act as applied to retail electricity suppliers. And we're supposed to be taking public comments today. I know we have some people here who want to speak. I believe I have a list here. Mr. Stevenson, are you the first one to speak?
You have to go to the microphone.
Yes, sir. Please come forward and identify yourself for the record and give us some of your words of wisdom with respect to these rules and regulations.
And I will pass the written comments. It's 1 page, 2 sides. I have already submitted. My name is David Stevenson. I'm with the Cesar Rodney Institute. I live in Lewis, Delaware. I've already submitted written comments earlier. These are an addendum to that with some additional comments. I will summarize these for you. I won't go through the entire 2 pages. First of all, thank you for opening this docket and for having this session to speak. I would like to say I appreciate the thoughtful approach that the PSC staff took in putting the proposed regulation together. I also appreciate the fact that they have removed from the previous regulations the externality calculations. Those are a problem. They're difficult to calculate. The legislature actually assumed that there were external benefits, unpriced benefits, when they allowed the 3% cost cap in the RPS cost cap calculation. Some of the things that make it difficult, for example, DENREC chose to continue to use the 2012 IRP for the emission rates and an EPA calculation of the health benefits, even though there was dramatic changes in both of those and more up-to-date documents. They've used the social cost of carbon from the federal government when we have our own cost of carbon right from RGGI. We see it every quarter. They have included the value of solar jobs, but didn't consider the fact that the higher cost of electricity because of the RPS is going to kill jobs in some places. So there's a lot of problems when you start calculating it. It depends on how you do it. So I'm very glad that that was removed. The big discussion point today is about the fuel cell cost. Now, the fuel cell cost is discussed in this proposed regulation, but it is not explicitly called out that it's going to be included in the calculation. And I think we need explicit wording that it's going to be included. The public advocate submitted comments that give very solid wording. I would defer to the wording that they have proposed for this particular thing. But I'd like to make just remind you, I was lobbying the legislature when the Fuel Cell Act was passed. I was an intervener during the fuel cell tariff. And just to remind you, when the tariff was passed, there was a cost cap that the cost of the fuel cell to customers on a monthly basis couldn't be higher than the highest existing tariff, which was determined to be Blue Water Wind. And that was, the PSC consultant said that was going to be $2.42 a month. The consultant also said that the fuel cell tariff would only cost $1.34 per month, so it was under that cost. That's levelized cost. But to get to that $1.34, the consultant used $1.96 for the value of the renewable of the fuel cell contribution to renewable energy. If the commission had not accepted that $1.96 as being a value, it would have been over the $2.42, and you would have had to voted against the fuel cell tariff. So right from the beginning, there was an assumption that the fuel cells would replace the renewable portfolio standard. Secondly, the commission staff, when DENREC proposed its 4th iteration of the cost cap regulations, after saying the fuel cells were included in the first 3, the PSC staff made these comments. The total cost of complying with the RPS necessarily includes the amounts paid by Delmarva customers as QFCP surcharges. As staff said, QFCP costs are borne by ratepayers, and one of the benefits is the fulfillment of a significant portion of the RPS obligation. Therefore, the QFCP cost should be included in the final rule because the ratepayer pays for this, and it is used for RPS compliance. I mean, this is the staff, claiming this very thing just 15 months ago. There seems to be a difference of opinion today. There is another issue that I have to attribute to Gary Myers. For those of you who don't know Gary Myers, he was the Deputy Attorney General for the PSC sometime in the past until he retired. There was a lawsuit in Maryland, Hughes versus Talon Energy Marketing. And the state of Maryland had decided to get new power plants built in Maryland that they would pay a premium cost for wholesale electricity. So what they would do is they would guarantee a certain wholesale price to this new generator, and then they would make up the difference from what they actually got from PJM. The case was decided in federal court that was illegal, that FERC has the power to set wholesale prices, and you can't get around that. Well, if we decide that we shouldn't count the fuel cell cost, we're basically saying that the fuel cell tariff no longer is counting the benefit of the RPS to ratepayers. They're giving Diamond State Generation a higher price for their market, and it falls directly into this Hughes versus Talon market case. It would present a possibility of someone suing over that issue to overturn the fuel cell tariff. If we're not going to give the ratepayers the benefits that we said we would give them from the RPS, that opens that door. In 2016, the Commission, in docket 12-250 and PSC Order 8835, said that on electric bills, we're going to show the qualified fuel cell cost as a part of the renewable compliance charge on the electric bill. So you've got a situation now where customers are seeing this cost on the electric bill, but yet under the old calculation and potentially under the current calculation, since it isn't specified, it may not be counted. Now, we said it counted. Let's make sure it does. Another point. There has been some discussion that QFCP shouldn't be cost because Delmarva doesn't actually pay for the RECs and SRECs that they get from the renewable portion of QFCP. If that's the case, then what if Delmarva built a solar farm? Would they not be able to use the SRECs from a solar farm? Delaware Electric Co-op actually has done that and is counting their SRECs against RPS. So if we're going to do it for a solar farm, we should be doing it for the fuel cell project as well. A couple of other issues. How do you do the calculation of what the percentage is of the higher cost of renewable compliance? What DENREC did was divide by the total cost of power to consumers. And that is the definition that the staff has put into this current proposed regulation. But yet, when you look at Section 354I and J, it clearly states to apply the statutory cost cap percentages against the total retail cost of electricity for retail electricity suppliers. In other words, the supply cost only. And that wording needs to be changed in this proposed regulation. It should be divided by the supply cost only. Difference is if you included the fuel cell cost, roughly we're looking at, if you divide by the total retail cost of electricity, including distribution and transmission charges, you're looking at a 9% cost. If you do it by just the supply, it's about 13%. It makes a big difference of how you what you're dividing by. And according to the statute, it should be divided just by the retail electricity cost to the electric supplier, not to the end user. Next piece is on the freeze consultation between the Division of Energy and Climate and the PSC. It has to have some definition. There has to be a mechanism. The public advocate has suggested it be considered a petition. I will not repeat all of their arguments why that's true. I will just concur with that there should actually be a process, and it needs to be laid out in this proposed regulation, which it's not, of how the PSC and DNREC will consult. There is no definition around that in the current proposition. And the final point, there is a specific clause in the proposed rules to exempt existing contracts from the freeze. There is actually no background given by the PSC staff as to why that is allowed. In the original docket 56 and your order 7933, March 22nd, 2011, a number of electric suppliers asked for such an exemption, that if they signed a contract, those contracts would be locked in. And the commission stated in their decision that they would not include an exemption provision because it was not included in the REPSA by the General Assembly. So if you're going to accept that there is an exemption for freezes, there needs to be some language, legal or procedural, that says you're allowed to do that because you've already turned it down once. So with that, if there's questions about my testimony, I'll be happy to answer it, but otherwise I'm done. Thank you for listening.
Thank you, Mr. Stevenson. Any commissioner have any questions of Mr. Stevenson at this time? Doesn't look like they do. Thanks again. Mr. Nichols? Welcome, Mr. Nichols.
Thank you, Chairman Winslow. I'm going to provide a few different copies of my brief statement. Okay. I'm sorry I don't have enough for everyone in attendance. And I do have an extra one that's distributed.
Okay.
All right. I'm sorry.
It was short.
Part of the public record, please. First, thanks for the opportunity to recognize me as a private citizen to comment on PSC regulation docket number 56. My original testimony was several pages long, but I had an opportunity to read the comments prepared by Regina Iori, Deputy Attorney General, and I felt that anything I had to say was redundant. So I've limited my comments to simply 4 items. First, I've reviewed thoroughly and wholeheartedly endorsed the comments submitted by the Division of the Public Advocate prepared by Regina A. Iori, Deputy Attorney General. The deficiencies noted in the regulations as proposed are unacceptable, in my opinion, and the changes that are proposed should be made. However, additional action may be called for under the circumstances. Second, the Delaware legislature placed a 3% cost cap on renewable energy charges, which, based on any reasonable reading of the statute, has been handily exceeded. In my opinion, which is supported by the DPA comments, A, the cost cap should apply to the supply charge on electricity bills, not the total amount billed, and B, qualified fuel cell provider charges should be included in renewable energy charges. On this basis, the renewable energy percentage is currently running about 15%, 5 times the statutory cost cap, 5 times. Third, the indicated remedy under the statute is to pause the phase-in of renewable energy requirements in order to prevent the 3% cost cap from being exceeded. And while the statute says this may, quote, end quote, may be done rather than it, quote, shall, end quote, be done, this was possibly intended to provide flexibility in the case of marginal or temporary overruns. It's hard to see how this wording could be stretched to excuse the large overruns that have developed without effectively treating the statutory cost cap as nothing more than window dressing. Fourth, it is suggested that the Commission should declare a pause in the phase-in of renewable energy requirements as required by the statutes, pending a complete review of this situation and the issuance of final regulations. That represents my formal remarks. I feel compelled, however, to say that I testified before the Commission with respect to the adoption of the feed-in tariff at 2 meetings. I testified at the hearing before the vote was taken. I've instituted 2 legal actions against the tariff, one against this Commission and former Governor Markell. And I also submitted, as part of the public record, a study that was conducted in Spain that explained that the public subsidies to aid alternative energy, I refuse to call it renewable any longer. It's not renewable, it's alternative. But in that study, it concluded that the levelized cost in Spain for support of wind and solar was approximately $216 per megawatt hour of generation. Those numbers are exactly in line with the Bloom costs, as 3 consultants hired by the staff of the Delaware Public Service Commission concluded. Exactly in line. We now know how poor Bloom's performance has been. That study predicted that the cost for the aid to public subsidies to alternative energy costs $450,000 per job. This is all information that I submitted as part of my public testimony, and that report is in the records. Former Secretary Levin, Dito, had a black box model. I'm quoting him, black box model. It predicted how great the economic benefits of Bloom would be. And I, at that time, said to Secretary Levin, you have a black box model, I have real world data. I don't want to say I told you so, but it's hard not to think back on that testimony that I provided and look at Bloom today and not say that I was absolutely right. That being said, I predict that Bloom will fail. They're entirely reliant on public subsidies. They're generators of hazardous waste, as noted in Region 3 and now Region 9. They violated EPA regulations for the transportation of that waste, and I fully expect that in the fullness of time, they will depart. But they have not yet departed, and we have paid them approximately, only Delmarva Power ratepayers have paid them approximately $150 million for dirty, expensive generation. To fail to include that cost when one recognizes that when the tariff was adopted, instead of the paltry 30 megawatts of generation Delawareans received from the 2 Bloom fuel cell sites, we could have had somewhere between 300 and 400 megawatts of generation instead of 30 megawatts for the same price. That, too, was part of my public testimony. So here we sit. this pause that I'm asking for is necessary, and including the Bloom fuel cell charge for dirty, expensive electricity is required. To do otherwise, in my opinion, would be a failure to balance the needs of the regulated utility Delmarva Power with the needs of the ratepayers. So with that, I will end my comments, and I thank you for your attention. If you have any comments of me, I'd be happy to answer them. If you have questions of me, I'd be happy to comment.
Anybody have any questions? Mr. Nichols?
Yes, Mr. Chair.
Mr. Gray?
I have one question.
None?
No, sir, we have a question.
Oh, I'm sorry. I'm hard of hearing. Pardon me. So speak up, please.
Yes, I will. I was just formulating my question. What is it in your mind that comprises a complete review of this situation by definition?
I addressed them in my secondary comments. Bloom Energy, which the proposed regulations will not be included in meeting the as it will not be included in determining the so-called freeze or cost cap, as it's referred to, requires an investigation. The authority for that investigation rests solely with this commissioner. And, in fact, Whipple versus Bloom Energy and Delmarva Power, a recently decided court case in that matter, said that it rests with the commission. It's your duty, according to the Superior Court of the State of Delaware, to take up the matter of Bloom Energy and the investigation that's necessary. I've made this comment before, and I've been told by others, staff, and others, that it's not in your purview, that it's actually in the purview of DENREC. But the State Superior Court does not agree with that assessment. So, in answer to your question, Bloom Energy needs to be examined by this body. We know that their economic predictions are failing abysmally. They're supposed to have 900 jobs by the end of this year. They're not going to come close. The recent job report, if I recall from memory, was supposed to be 900. It was 245. No penalty has been applied to them for failure to reach those job totals because the strategic grant agreement did not provide for penalties until this year. They're not going to have 900. The question is, will they have the money to allow us to claw back some of the dollars that DITO had expended? As I said, they are under investigation by the SEC. I have proof of all of this. The SEC, the FBI, the FTC, Region 3 of the EPA, and now Region 9 of the EPA. And to say that this should not be included as a cost when it has already been $150 million of only Delmarva Power ratepayers, I might add. And as the commissioner knows, I challenged that feed-in tariff as supported by the Markell administration. I wasn't granted standing. My co-plaintiff, Fuel Cell Energy, was granted standing, but they chose not to proceed for reasons I really can't explain, but I can only speculate on. And since it's speculation, I'll choose not to do that. But the Markell administration said in the future, we'll make certain that any qualified fuel cell provider, it's a competitive bidding process. And they reasonably acknowledged that perhaps that's the way it should have been done without admitting any guilt. But the case was settled out of court. The administration paid the legal fees associated with the lawsuit, and that was the end of it. So this is a big, big problem in Delaware. And it rests on the commissioners, according to the Superior Court, to resolve it.
Mr. Nichols, you've worked long and hard on this particular issue and other issues, and we appreciate your comments, and we will obviously give them serious consideration. And you're so upset about this, I think you've affected the weather outside. It's gotten darker since you started speaking.
A cloud follows me wherever I go.
I don't know if that's if you're trying to send us a message or not, but hopefully between the comments that have been made and the future comments of the people that are going to come after you, and Ms. Iori and the staff contemplating them, we'll come up with something hopefully will be maybe not agreeable to everybody, but at least acceptable to everybody.
It was my intention I have submitted a petition to intervene in docket number 56 that the staff has not yet provided to the commissioners. I'm now going to ask that at the conclusion of this meeting, the end of today, they do submit that so that as this matter progresses and the regulations are adopted, I have an opportunity to offer further comments.
Just make sure that whatever motion for intervention you make, you review the rules and regulations of the commission and point to the areas of the rules and regulation that buttress your opinion that you should be an intervener. That would be helpful.
I'm not sure you can intervene in a regulation
we're not going to
document.
discuss whether he can or can't intervene. I was just giving him some gratuitous advice about whatever he's going to do with respect to the intervention.
I appreciate that.
Staff will take its position, and we'll discuss that when it's appropriate.
I agree. Thank you very much.
Thank you,
Appreciate
Mr.
your attention.
Okay, Heather Thompson. Welcome.
Thank you. Thank you for the opportunity to present comments today. My name is Heather Thompson. I'm here on behalf of the Mid-Atlantic Renewable Energy Coalition. MERIC is a nonprofit corporation that was formed to help advance the opportunities for renewable energy development, primarily in the PJM region, including Delaware. MERIC's membership consists of wind and solar developers, wind turbine manufacturers.
Could you slow down, hon? Please.
I can give you this after I finish, if that'd be okay. And I will try and slow down as well. Sorry.
But if you slow down, she'll then be able to have less to correct when she looks at it.
MERIC's membership consists of wind and solar developers, wind turbine manufacturers, service companies, nonprofit organizations, and a clean energy transmission company. I'm here today to support the implementation of RPS and cost cap regulations as proposed by staff here at the PSC. This will clarify the proper administration of the cap per the recent court decision and does not impede on the statutory discretion provided to the Director of DENREC's Division of Energy and Climate pursuant to sections 354I and J of the Delaware Code and the General Assembly's explicit declaration of the RPS laws that declares that the benefits of electricity from renewable energy resources accrue to the public at large. The RPS was instituted not just to meet the electricity needs of Delawareans, but also to increase the supply diversity, reduce price volatility, provide environmental benefits such as cleaner air and water, and promote new economic development opportunities through the development of renewable energy in the state. While these proposed rules do not address DENREC's inherent discretion in the relevant statute that I mentioned, it is important to note that these benefits fit the General Assembly's policy statement in the RPS law. These benefits would be appropriately determined by the Director under the discretion provided for his or her determination to freeze or not to freeze the RPS requirements for a compliance year if the calculation provided by the PSC proposed rules are exceeded. Although one party has argued that may equals shall for the purpose of this rule, we completely disagree and support these proposals that in effect leave to the Director to ultimately determine whether a freeze is appropriate if the provisions are triggered. MERIC believes that this is the true intent of the General Assembly. Otherwise, the legislation enacting the cost cap provisions would have used the word shall, and that word was simply not utilized, and therefore a hard freeze is not a statutory requirement in this case. Thank you for the opportunity to provide comments today.
Any questions, Commissioner? Ms. Thompson, thank you very much for coming forward to represent MERIC. We appreciate it. Mr. Noyes?
Thank you, Mr. Chair. I wish to provide brief comments on behalf of DENREC in advance of written comments that we plan to submit in this docket. In doing so, I'd like to update the Commission on DENREC's process to repeal its Regulation 2102 coming out of the twin lawsuits, DPA versus PSC and DPA versus DENREC. First, on DENREC Regulation 2102, as you recall, DENREC promulgated Regulation 2102 titled Implementation of Renewable Energy Portfolio Cost Cap Provisions in response to a petition for rulemaking more than 5 years ago. I'll skip all the intervening history if you don't mind. In response to Judge Abigail LeGros' memorandum opinion in DPA versus PSC, DENREC, with the concurrence of the public advocate, moved to stay the proceedings to allow for the administrative repeal of Regulation 2102. The repeal was published in the March 1st Register of Regulations and is proceeding per the Administrative Procedures Act. Repeal of a regulation is handled in the same way as an amendment of a regulation, except that in this case, the amendment is to strike the regulation in its entirety. The division held a hearing on the repeal of Reg 2102 on March 22nd, and the public record will close tomorrow, April 7th. Anyone wishing to comment in that proceeding can email me at thomas.noyes@state.de.us or go to the Register of Regulations and look at the instructions there. As for the further progress, our attorney recently informed Judge LeGros that we expect to publish the final repeal in the June 1st Register. Turning to PSC's regulation docket number 56, the Commission, in its order reopening Reg Docket 56, did so for the limited purpose of complying with a memorandum opinion in DPA versus Public Service Commission. The DENREC Division of Energy and Climate generally supports PSC staff's proposed revisions of Reg 3008 as consistent with REPSA, that's the Renewable Energy Portfolio Standards Act, the memorandum opinion in DPA v. PSC, and with order number 9025. We've planned to file written comments with greater detail by April 24th. That's all I have for now, and be happy to answer any questions if commissioners have any.
Commissioners, any questions?
No.
Thank you, sir. Appreciate it. Now that seems to have exhausted the number of people on the list I have who wish to speak at the public hearing. Is there someone who wasn't aware that they had to sign up that still wants to speak? Okay. Well, they're going to have a chance to speak, obviously. Okay, I see no one else who wishes to speak, and Ms. Iori likes to get the last word, so we'll give it to the public advocate.
Actually, Mr. Slater is going to have the last word.
Yes, this is going to be me. Mr. Chair, Commissioners, I just wanted to take a second to add some comments to our already filed comments in Docket 56. I actually worked in the legislature when these laws were passed. I have intimate knowledge of these laws, and I know the intent was always to include Bloom as the qualified fuel cell provider. Additionally, I spoke with former Secretary O'Mara in the last month about this, and he again confirmed that his intent was always to include Bloom. So I just wanted to add those comments to the record, having been there and then having talked to Secretary O'Mara, that it was always the intent of the legislature and of DENREC to include Bloom in the RIPSA. Thank you.
Thank you very much, Mr. Slater. Commissioners, anybody have any questions or thoughts or that you want to share anyway? Okay, I believe that concludes that matter, the hearing on the adoption of rules and procedures to implement the Renewable Energy Portfolio Standards Act. Thanks once again to everyone. We'll go on to the next item, which is public comment. Is there anyone else here from the public who wishes to make any comment to the Public Service Commission? Seeing none, I would ask that Mr. Howard go to his director's comments.
Chairman Winslow, Commissioners, appreciate the opportunity to address you in this wonderful weather conditions that we're having out there. You probably want to hurry and run home or something like that just to avoid all this wonderful weather we're having. In any event, I did have under administrative matters that staff was going to discuss proposed changes to Delmarva's request for proposals for the full requirements wholesale electric power supply. That is a very difficult issue to address in some respects, and what we would like to do is to defer further comment and review with the Commission until the April 20th meeting, if that's appropriate, and we will be better prepared at that point to discuss in more full fashion the issues associated with that, if you concur with that.
Absolutely.
Okay, item number 2. For those of you who are not aware, there was an evidentiary hearing scheduled on the the Delmarva gas case, docket number 16650, was held this morning. Please don't rush up to the Carville State Office building. That meeting was concluded about 10 o'clock. So the hearing is complete. There is also, according to my next bullet, a hearing scheduled for that same docket tomorrow. That docket is no longer requires that hearing, so those basically are not going to happen at this point. So just to make you aware, there's no need to rush to the Carville State Office building on Friday either, because there won't be any evidentiary hearing going on there. There will be an evidentiary hearing on the PSC docket number 160889, which is the gas cost rate, that will be held here at the April 20th meeting at in our office here at the Commission meeting. A note that's not on here that you should be aware of, we will be having a public meeting with the residents of Holiday Pines regarding their water service, and that meeting will be held on Wednesday, April the 19th at 6:30 p.m. at the Mid-Sussex Rescue Squad in Millsboro. We have been discussing with them and with Tidewater an approach to resolve some water company issues in that case, and this will be an opportunity for the public to weigh in and to understand what we're trying to do there. And lastly, we will have our next Commission meeting will be on Thursday, April the 20th. And I thank you, sir.
Thank you, Mr. Howard. Commissioner Gray?
Thank you, Mr. Chair. Off the record, just 1 hour before this meeting, I sat in a conference, National Gas Committee with NARU, and I learned a lot about the gas quality and moisture and hydrocarbons and transmission and processing. And they pointed out to me that, some challenges they have is that biogas is beginning to enter the natural gas distribution network. And so they've worked on programs to capture natural gas from cattle waste, and they call it Catalytic Recovery Animal Process, which acronyms to CRAP. So I just wanted to end this session with a little bit of humor because I couldn't stop laughing at the end of my conference. Thank you, Mr. Chair. Appreciate it.
Thank you.
You think they did that on purpose?
No.
Adds a little sensory perception to our meeting. Okay, thank you all. The meeting's over with. It's adjourned.